There was a phone on the evidence table, a rose gold case with a cracked corner. The screen still had notifications on it when they brought it in. I could see them from the bench, though I could not read them from that distance. I did not need to. I already knew what kind of notifications they were. That phone is what I keep coming back to. Not the building, not the fire trucks. That phone. This is that case. Before I go further, and I want to go further, because this story deserves to be told completely, I need you to subscribe and turn on notifications, not as a formality, because there is one piece of evidence in this case, something small, something easy to overlook, that changed the entire direction of my ruling. I want to make sure you are here when I get to it. Subscribe now, then let me continue. The victim's name was Marcus Aldridge. He was 43 years old. He walked into my courtroom on a Tuesday morning in March, wearing a gray button-down shirt with his left sleeve pinned at the elbow. I noticed that first, the pinned sleeve. He sat at the plaintiff's table, opened a folder, and started reading. Not looking around, not watching the door, just reading. Most people who come into my courtroom look at me first. Marcus Aldridge looked at his folder first. That told me something about him. He had a particular way of listening during testimony. He would sometimes close his eyes. His attorney told me in a sidebar that it helped him hear more clearly. When he opened them, he was always focused, always tracking. He never looked at the defendant, not once across 3 full days of trial. That kind of discipline is hard to maintain. He maintained it. The defendant was Cassandra Vale, 29 years old. 1.4 million followers on a platform that was named extensively during the trial. She came in with her attorney on one side and a woman I later learned was her publicist on the other. The publicist was asked to sit in the gallery, which she did with visible reluctance. Cassandra herself was dressed carefully, not extravagantly, carefully. There is a difference, and she understood it. She had a habit, when she was not the focus of attention, of reaching into her bag and then stopping herself, like she was looking for her phone and remembering it was in an evidence bag. She did that 9 times over the course of the first day. I counted. I count things from the bench. What I noticed most was where her eyes went when witnesses were speaking. They went to the gallery, specifically to the phones in the gallery, not with hunger, just automatically, the way a person responds to a sound they have been trained to answer. I want to be precise about what happened, because this case attracted a particular kind of attention that invited imprecision, and I have no patience for that. On the afternoon of September 14th, a Wednesday, there was a gas line rupture in the basement of the Fentress Arms apartment building at 2204 West Oleander Street. The rupture was detected at approximately 2:17 p.m. The fire department was called at 2:19 p.m. 3 ladder trucks and 2 rescue units were dispatched. The first unit arrived on scene at 2:26 p.m. The fire lane on the east side of the building, the only lane wide enough to position the aerial ladder required for the upper floors, was blocked. There was a white Mercedes-Benz GLE parked there. The driver was still inside. She was live on her phone. She was broadcasting. The building was visible through her windshield. She had positioned herself there because, in her own words, preserved in the stream entered as evidence, it gave her what she called the most insane backdrop. Then she said, "I am literally getting exclusive content right now." The aerial ladder could not be positioned on the east side. It had to be repositioned to the north, which added 11 minutes to the extraction of residents on floors 7 through 9. Marcus Aldridge was on the 8th floor. He evacuated by stairwell along with 14 other residents. During that evacuation, there was a secondary pressure event, the fire marshal's term for a partial collapse of the eastern stairwell wall at floor 3. Marcus was on that stairwell. He was thrown into the railing by the pressure. His left arm was trapped. By the time he was extracted and transported, the damage was not repairable. He lost the arm below the elbow. Cassandra Vale did not know the full extent of what was happening while she was live. That was argued by her defense, and I heard it. I gave it weight. But what the stream recorded was that she remained in that fire lane for 22 minutes after the first fire truck arrived and parked directly behind her. She was asked to move 4 times. She acknowledged at least one of those requests on stream. She said, hold on, they want me to move, but I literally just started. I have 40,000 people watching right now. If you're the kind of person who stayed with this story this far, not because it is dramatic, but because you actually want to know what happened, then you already understand why I am telling it. Subscribe. This is what I do now. Tell the stories that need to be told. The legal process in this case was not straightforward. Cassandra Vale faced a separate criminal matter, obstruction of emergency services, that was resolved before my courtroom was involved. What came to me was the civil action. Marcus Aldridge sued for negligence. Medical expenses, lost income, permanent physical impairment. There is something about civil negligence that most people misunderstand, and I heard enough commentary about this case to know the confusion was widespread. Intent is not the standard. The standard is duty, breach, causation, and damages. 4 elements. I was measuring everything against those 4. Cassandra Vale's legal team focused their argument on causation, specifically that the secondary pressure event was not a foreseeable result of the blocked lane and that the structural failure broke the chain of cause and effect. That is a legitimate legal argument. I treated it as one. What complicated it was the evidence. It came in 3 waves and they hit the courtroom differently from one another. The first wave established the baseline, the stream footage, the fire department response logs, the timeline. Captain Renee Farrow's testimony from the stand, delivered without drama, the way a person speaks about their own professional reality. She said, "We are trained to adapt to obstacles. We adapt every day, but there are some positions that cannot be adapted away. That lane is one of them." She said it like she had said it before. I believed her without question. The second wave introduced complication. Cassandra Vale's defense entered a building inspection report, filed 2 years prior, documenting pre-existing structural weaknesses in the eastern stairwell. It had not been acted upon by the building's management company. This was relevant. It was not exculpatory, but it introduced comparative fault and made the causation analysis more layered than a straight line between the blocked lane and the lost arm. I watched Marcus when this evidence came in. He did not close his eyes. He looked at his folder. His right hand was flat on the table, not a fist. Just a hand pressed flat against paper. I noticed it because it was the most controlled thing I had seen in 3 days of testimony. The third wave was what changed the shape of the case. I want to stop here for a moment, because what I am about to tell you is the part of this case I had to sit with the longest before I felt ready to speak about it publicly. Subscribe before we go further, then take a breath, because this next part matters. On the 3rd day, a digital forensics analyst testified. She had been added to the witness list late, with leave of the court, which I granted after reviewing what she would say. She testified about the metadata embedded in Cassandra Vale's live broadcast. Specifically, she testified about a geo-fenced emergency alert that had been delivered to Cassandra Vale's phone at 2:24 p.m., 2 minutes before the first truck arrived on scene. The alert specified a fire emergency. It instructed anyone within a quarter-mile radius to clear the area. Cassandra Vale received it on the same phone she was using to stream. The stream continued for 22 minutes after that alert was delivered. I asked the witness to repeat herself. She did. I wrote it down. The defense argument was organized, and I will give it to you straight because I believe in giving the defense a fair account. 3 arguments. First, she did not know the severity of the situation. Second, she was not the only vehicle in the area. A news van was present on the north side, and she was singled out because of her public profile. Third, the primary cause of Marcus Aldridge's injury was the building's structural failure, not her presence in the fire lane. These were not weak arguments. The first had real weight until the emergency alert evidence arrived. The second had factual support. The news van was documented. It had also been asked to move, and it moved within 4 minutes of the first request. The third engaged the causation question seriously. Her legal team was thorough, I want that said. Cassandra Vale chose to testify. On direct examination, she was composed. She described her platform, her process, her spontaneous decision to stop when she saw smoke while driving past. She said, I never thought for a second that I was making anything worse. I wrote it down. On cross, she was asked about the emergency alert. She paused. She said she received a lot of alerts. She said she did not always stop to read them during a live stream. Then she was asked, would she have stopped streaming if she had known what was happening on the 8th floor? She said, I would like to think I would have. I would like to think I would have. I wrote it down. I have been doing this for 21 years. The cases I choose to speak about publicly are the ones I believe need more people to know about them. Subscribe and tell me in the comments what is hitting you hardest so far. I read what people write. It matters to me. Years ago, before I sat on the bench, I was walking through a hospital corridor. Not as a patient. I was there for something routine on my way to an appointment in a hurry. There was a situation in the hallway. Someone needed help. I could see it. I made a fast calculation about whether I was the right person, whether someone else would handle it, whether I had the time. I kept walking. I made my appointment. I found out the next day the situation had been more serious than it looked from a distance. The person was fine, eventually. But I spent a long time after that thinking about the calculation I had made, whether having somewhere to be was a sufficient reason. I am not saying that situation and this one are the same. I am saying I understand how a person can be in the middle of something and not fully see what is around them. I have been that person. That is the only reason I am mentioning it. When I came out to deliver the verdict, the room changed. Not completely. There is no such thing as complete silence in a courtroom. But the quality of the noise shifted. Cassandra Vale had her hands folded in front of her. She looked at me with a kind of attention I had not seen from her in 3 days. Like she had finally set down a phone that was no longer in her hands. Marcus Aldridge had his folder closed. His right hand was resting on top of it. I had made my decision days earlier, if I am honest. But the moment still lands differently when it is spoken out loud. I found for the plaintiff, I found that Cassandra Vale had a duty to comply with lawful emergency directives, that she breached that duty by remaining in the fire lane for 22 minutes after being asked to move. That the breach was a substantial contributing cause, not the sole cause, but a substantial contributing cause, of the 11-minute delay. And that the delay materially worsened the conditions under which Marcus Aldridge was injured. The comparative fault analysis allocated 60% of the negligence to Cassandra Vale. The building's management company, joined as a co-defendant, had already settled. The verdict against Cassandra Vale covered the remaining portion. The verdict was not the hardest part of this case for me. The damages were, because that is where I had to decide not just what was legal, but what was right. Subscribe so you do not miss what I decided. I am getting to it now. I am ordering you to pay $847,000 in compensatory damages. This covers Marcus Aldridge's full medical costs to date, the projected expense of prosthetic fitting and rehabilitation, and the documented income loss from his licensed electrician position, a position that required 2 functional hands and that he can no longer hold. This is not a punitive figure. This is the arithmetic of what was taken. I am also ordering $340,000 in punitive damages payable to the Marcus J. Aldridge Foundation for First Responder Access Advocacy, which Mr. Aldridge established after this case was filed. Punitive damages require a finding of reckless disregard for the safety of others. The emergency alert evidence established that finding. You had a warning in your hand. The stream continued. There is one more thing. Within 60 days of this order, you are required to produce, fund, and publish a minimum 45-minute documentary, not a post, not a clip, not a segment, about fire lane obstruction and emergency response access. It will be produced in consultation with the Fire Marshal's office, subject to my review before publication. It will include Captain Renee Farrow's testimony about what an 11-minute delay means in practice. It will include an on-camera interview with Marcus Aldridge if he consents. If he does not, that portion will be replaced with testimony from another survivor of delayed emergency response. The documentary will be published on every platform where you maintain an audience of more than 10,000 followers. It will remain pinned to your primary channel for a minimum of 6 months, and the $14,200 in platform revenue generated by the September 14th stream before it was taken down, that figure is in the record, will be transferred in full to Mr. Aldridge within 30 days, with documentation. Before I closed the session, I spoke directly to Cassandra Vale. I want to tell you what I said, because I have thought about it since, and I stand by every word of it. I told her, on September 14th, you were in a place where something real was happening. You had the ability to move. You had been asked to move 4 times. You had received an automated emergency alert that told you to clear the area. You had 40,000 people watching, and you stayed. Because of the 40,000 people, I want you to sit with that sequence and with what it cost Marcus Aldridge, not in the abstract, but in specific terms. 1 arm, a career he spent 15 years building, the ability to do the work he loved. That is the material cost of 22 minutes. I said, I understand that your family is in this room. What I say to them is only this: the people we love are capable of more than the worst thing they have done. I believe that. I apply it to every defendant who has ever stood in this room. I said, a platform of 1.4 million people is not just an audience. It is a position. Positions carry weight in proportion to their reach. Then I said one final thing. I do not believe you are without conscience. The sentence you gave on cross, I would like to think I would have told me more about you than 3 days of prepared testimony, because it was honest. You did not know what you would have done. You are going to spend some time finding out what that means. I think that is appropriate. Then I closed my notes. Then I dismissed the session. Thank you for staying with this. I mean that. Subscribe if you have not yet. You already know why you are still here. As the courtroom emptied, I stayed on the bench. There was a woman in the gallery. I never learned who she was. She was not in the record, who had sat in the 3rd row for all 3 days. When the verdict was announced, she made no sound. But as the room began to move, she reached over to the woman beside her and held her hand. Not a squeeze, just held it. The 2 of them sat still while everyone else gathered their things and filed out. I watched that from the bench, and I let the room finish emptying before I stood. When I finally rose, the room felt like a room that had been used for something serious and left changed by it. Cassandra Vale's attorney filed an appeal within 60 days, which is standard. The appellate division heard the case and affirmed the verdict in full. Their ruling addressed the causation question directly and cited the emergency alert evidence as establishing the proximate cause chain. That took 9 months. I was not surprised, but I was relieved. On March 3rd of the following year, Cassandra Vale published the documentary. I watched all 47 minutes. It was not a performance of remorse. It was an actual accounting of what emergency access requires and what obstruction costs. Captain Farrow appeared on camera, exactly as plain as she had been on the stand. Marcus Aldridge did not participate. He chose not to, which was entirely his right, and the film noted that clearly. In the final segment, Cassandra said something that was not in the required script. She said she had never thought of a fire lane as something that existed for a reason. She had thought of it as empty space. I found that more honest than most of what she said in my courtroom. Here is the question this case left me with, and I have not resolved it. When does the presence of an audience, not just a live stream, any audience, any situation where people are watching, change the decisions a person makes in real time? Not the morality of those decisions, the actual mechanics, the millisecond calculation. I am not asking whether wanting an audience is good or bad. I am asking whether the audience, once present, changes the circuitry in ways the person cannot fully override. Because if that is true, and I think this case suggests it may be, then the question of what we are building when we build platforms is a different question than the one we usually ask about them. I keep turning it over. I have not stopped. If you have ever been in a moment where something was happening around you and you did not fully act, not from cruelty, not from indifference, but because something else held your attention, some pull, some momentum you were already inside, then you know the particular texture of that memory. It does not feel like a choice. It feels like something that happened. But Marcus Aldridge is living in the result of it. That is the distinction. What feels to one person like something that happened is, in another person's life, something that was done to them. I have seen that gap many times. I have never stopped being struck by it. And if you have built an audience, any size, any platform, and you have felt that pull, the pull of the number in the corner of the screen, the pull of staying when something in you knows you should stop, I am not here to condemn you. I am asking you one question, a real one. What is the moment worth, not the content? The moment itself, where you are actually alive and the people around you are actually alive, and the lane that needs to be clear right now. What is it worth? You do not have to answer me. But I think you should answer yourself. There are other cases I want to talk about. This is not the only one that stayed with me. Subscribe and you will hear them when I'm ready to tell them. There was a rose gold phone on the evidence table, cracked corner, notifications on the screen that I could see but not read. Someone had logged it, bagged it, and carried it into my courtroom, and it sat there for 3 days while everything this case contained was laid out around it. I keep thinking about it. Not because it was the most important piece of evidence, though it was important, because it represents what this case was actually about, not negligence in the legal sense, what we reach for, what we do not reach for, what that gap costs someone else. That is why I told you this story. If you want to hear the others, and there are others, subscribe. That is all I am asking. Subscribe and stay. The comments are where people who care about the same things find each other. Whatever you are thinking right now, write it down. I will read it.